Good morning, and thanks for joining us for another edition of the Elville webinar series. Today is Thursday, March 20th, and our topic is a new one for our series titled Documents for Life and the Family Love Letter. We have two outstanding presenters today to share information and education with you. Lilly Hummel, Principal Attorney and Leader of the Rockville office here at Elville & Associates, and Cortney Heykoop, a Chartered Special Needs Financial Consultant with Clover Wealth Strategies. I'm Jeff Stauffer, and I'll be taking you through today's presentation as your moderator. A few housekeeping items as we get started. We always encourage your general questions here on our webinar series, so please note them in the questions panel or the chat, and we'll address all those questions at the end of the presentation. Your questions add a lot of value. They help others learn, so don't be shy in posing your questions. More specific questions to your individual situation may be best suited to be talked about in a discussion with Lilly or Cortney offline. And also this morning by email, you received the presentation slides for today's presentation. They're also available in the section marked handouts to download at this time. We have several advisors on today's presentation, so welcome to you as well as always. We offer 1.5 continuing education hours for attending. So I have most everyone's ID number or accreditation. If I don't have it though and you're new to it, please send that over to me and I'll make sure that we get CE hours and certificates sent out very quickly. And everyone will also receive a post-webinar feedback email right after the presentation. This is very brief yet important to us, so please take just a couple minutes to share your thoughts about the presentation. And a question for you. Have you achieved your planning goals, or have those goals shifted since you last looked at your planning? And here at Elville & Associates, we always want to be a resource for your family's planning needs, and whatever that may be, starting from the beginning, older documents that might need to be addressed, administration matter, or something completely different. Lilly and our team are here to advise and counsel you every step of the way, understand your situation, create solutions, and a path forward for you. So Lilly and Cortney, welcome. It's great to have you both here. This is the first of a two-part series with Lilly and Cortney, and looking forward to getting started. So Lilly, I will let you take it away. If you'd like to both briefly introduce yourselves, please do so.
Sure, thank you, Jeff. Right, why don't we start with Cortney and I each introducing ourselves. As Jeff mentioned, I'm a principal attorney at Elville & Associates. I lead our office in Rockville in Montgomery County. I am a special needs planner and estate planner, so I do a lot of regular estate planning. I work with families on guiding them through the estate planning process, and today we're going to be talking about the documents, but also the bigger picture beyond just the documents you need for estate planning. And then as Jeff alluded to, I do have a focus on special needs planning, particularly where a family has a loved one with a disability. So that will be the focus of our second presentation. I'm licensed in Maryland and DC, and I primarily work here in Maryland. So I'll turn it over to Cortney just so she can give her introduction as well.
Good morning, all. My name is Cortney Heykoop. I am a financial advisor and chartered special needs consultant. I specifically work with families who have special needs children, whether that child is 5 or 55. Above all, I'm a special needs mom myself, and that's kind of how I merged my career and my personal life when I realized that there were not a lot of me's who really truly understood families like mine and help us navigate the complexities of government resources, planning for retirement that may include 3 instead of 2, and how we plan for life for our child once we're gone. And that partnering with attorneys like Lilly is key to that. And we're very glad to be here with you today, and again in April when we go into the special needs a little bit more. I am licensed throughout the country, Massachusetts to California. Maybe I skip over a couple states in between, but can be licensed anywhere in the United States. All right, Lilly, let's get into documents for life here. And then once you've gone through that, I'll kind of talk about the softer side of it with the family love letter. How's that sound?
That's perfect.
Great,
so
take it away.
A brief disclaimer, this is education only. This is not specific legal advice, and I can't answer any questions about your specific situation during this seminar. So a brief overview of what I'll be covering today, the documents for life portion, estate planning. So what is estate planning? What does it mean? If I had to break it into two parts, I would say there's the incapacity planning. So while someone's alive, if they're unable to manage their own affairs. I'm going to discuss the post-death asset transfer and the types of documents and considerations that we review when we're doing estate planning for somebody at that point. And then different ways to think about your estate planning approach. And that's going to lead in really well to Cortney's presentation about how to actually make this work for you and your family as smoothly as possible. So I have to just start by posing the question, why plan? And the reason I have this here is to point out my clients come in, everybody has their own goals and values. So a big part of my job is helping a client articulate for themselves what their goals and values are. Sometimes we have to force rank an ordering of their goals and values because we are going to work to achieve 100% of as much as we can. That's not always possible though. We can't always have maximum flexibility and maximum asset protection preservation. So part of the process is this conversation about planning to ensure that we articulate your goals, your values, and we have things set up to achieve them. What is estate planning? What am I talking about? So I think it's helpful to view estate planning on a time continuum. So if we think about time as during a person's life and post-death, and if we break it down even further, during life, we have an evolution for some people. While they have capacity, they understand what they own and the implications of their decisions. And then for some people later in life, there is waning capacity. Capacity isn't linear. It may go up and down over the course of a day, weeks, months. It could be, it's pretty common for someone with a dementia diagnosis that in the morning they're more clear and understand these types of legal conversations, but by evening they have sundowning and they don't. So by the end of their life, maybe they don't have capacity. So for this during the lifetime segment of our planning, we're usually talking about two documents, which I'll review, the financial power of attorney and the healthcare advance directive. And then we get into the post-death considerations. So we're going to talk about the last will and testament, what happens to joint assets, what happens to assets that have a designated beneficiary. And throughout all this sort of through line in our planning are various types of trusts, which we'll talk about just briefly. So I'm going to start out by addressing estate planning during life. What are the kinds of documents we need in place in case there's some sort of unforeseen incident, such as a car accident or a stroke, or a diagnosis where there's going to be likely going to present as a gradual decline in a person's capacity to manage their own affairs. So for incapacity planning, first off, what we talk about is a financial power of attorney. This is a document that legally authorizes another person to act as your agent, to step into your shoes, to do the same sorts of legal actions that you are able to take for yourself. Banking, real estate, signing contracts, filing taxes. Those are all the kinds of activities that you're legally designating another person to manage on your behalf in the event that you're alive but not well. And so during our estate planning, we talk about the Maryland statutory form if you're a Maryland resident, why most people also benefit from having a general durable power of attorney, which provides more comprehensive authority for your agent. The types of authority granted, if you have specific concerns, how we can tailor it based on your circumstances. And then if you do have a trust, we talk about how to make sure that your living trust aligns well with whatever is in your financial power of attorney. The second document for incapacity planning is an advance directive for healthcare. And this can be confusing because different attorneys, and if you look around online, use different terms to sort of mean the same thing. In essence, we're talking about a couple different pieces that together comprise an advance directive for healthcare. So one piece is, of course, naming a healthcare agent. It's not meant to replace your decision making. It's meant to help supplement in the event you are unwell, cannot articulate your own needs. So who has the authority? Oh, I'm so sorry about that. Who has the authority to work with the doctors, access your medical records? And then what are your preferences regarding life support? Some people call this a living will. Some people call this treatment preferences. It's all driving towards the same goal, which is, what are your preferences in the event that you're in, for example, a persistent vegetative state? Those are discussions we have. And the last piece of an advance directive is instructions post-death. So that if you want to be an organ donor, burial preferences. So this is really an opportunity to document your personal preferences. And I just want to be clear, this is not a DNR. A do not resuscitate order is a medical order. It has to come from a licensed healthcare practitioner, like a nurse practitioner or a doctor. It is an actual medical order to whatever medical personnel are on site if you go into cardiac arrest, not to resuscitate. That is, in the moment, a treatment plan. What an advance directive doing is a document drafted by an attorney. It is instructions for the legal authority to act on your behalf if you can't articulate your wishes yourself. So taken together, those are the documents for incapacity planning. So then we move into post-death planning. And I would say that the majority of people, when they say estate planning, when they come in, they have these two questions or two statements I hear. I need a will, and I have been told I want to avoid probate. Those are the kinds of things that people tell me. And that's fine, I understand that. My feedback is that good estate planning that really achieves your goals is about so much more than having a will or avoiding probate. I also find that a lot of people come in and they don't actually know what probate is. They just know they have been told to avoid it. So I just want to take a minute and get into the legalese of what is probate. Probate is the court process of overseeing the distribution of assets. The easiest example is you own a car, it's in your name. If you pass away, somebody needs to have the legal authority to go to the DMV and manage that asset, sell it, transfer title. If they've sold it, manage the money in accordance with your will or the Maryland laws of intestacy, which mean the Maryland laws defining next of kin for who receives the car or the sales proceeds of the car if you don't have a will. It's the court oversight, and that court oversight is done by the circuit court in the county where you're living when you pass away. Each state sets its own rules and each circuit court implements the rules. It is a vastly different process by state. It's even a different experience by county. For example, in Montgomery County, I have found the staff here accessible, responsive. It doesn't mean everything always goes smoothly, but when I work with my clients, I find it's really just a level of paperwork that we go through. It is not such a terrible process that the internet makes it out to be. But in other places, in other states, it is a years-long process that will hold you up from distributing your loved one's assets. So probate avoidance is a goal that we really need to tackle from the outset. So as people say, I need a will and I need to avoid probate, I also find that a really helpful point of clarification is there are different tracks for how assets are distributed. It depends on how the asset is titled. It depends on if it's joint or in a trust, or for a house if there's right of survivorship. It also depends on, for financial accounts, if you have designated beneficiaries or payable or transfer on death designations recorded. All of that, designated beneficiaries, for example, is going to supersede anything you've written in your will or in a trust. You designated while you're alive and have capacity to the bank or the financial institution what you want to have happen to your assets. So it doesn't matter what's written in your will or if you don't have a will. If your financial account has a valid designated beneficiary, the financial institution is legally bound to push out those assets according to whatever you wrote while alive. So a big piece of estate planning is harmonizing all these different tracks for distributing assets. That everything else is probate. So anything that is not titled to a trust, and we'll talk about trusts in a minute, is not jointly owned, where there's a survivor who'll then own that asset. There's no payable on death, transfer on death designation for the financial account. Everything else is going to go through that probate process I described. And that's that court review of the asset transfer. We get to the all these different ways. That is not probate. It's not going through the court review. So we need to make sure that we're really clear on what is the asset, how is it, what track is it going to be on, and have we taken all the steps to make sure that it aligns with your larger plan. So after a person passes away, if you've ever had a loved one pass away and you've been responsible for their estate, you know that it really can be a jigsaw puzzle. So we're looking at what's written in your last will and testament. We're looking at the designated beneficiaries. We're confirming the titling of all your assets to make sure that everything syncs up the way that you want it to. And so if your will has specific instructions, but you never updated your designated beneficiaries, so if the majority of your assets are in an IRA and you titled that years and years ago to go to your current spouse, and then that spouse has passed away and you never updated it, and now you've got a new partner, that new partner is not entitled to anything despite what's in your will because of what you have recorded for that IRA designated beneficiary. So a big part of good estate planning is this comprehensive review. I just want to take a couple minutes to talk about the revocable living trust. People, like I said in the beginning, often come in and they say, I need a will. And then some people will say, I need a trust. And I really want to highlight the point written at the bottom of the screen, which there are many, many different kinds of trusts, and they do different things. There's not a single type of trust. I think it's simplest if you think of a trust as a contract that is essentially an instruction manual with binding instructions regarding what happens to the assets titled to the trust. So instead of your house being titled to you, the individual Joe Smith, it would be retitled to the Joe Smith Revocable Trust or Living Trust. Joe Smith is the grantor. He's establishing the trust. He's probably the trustee while he's alive. He's the person responsible for managing the assets titled to the trust. So that's the house. He retains total control while alive over the assets. He can make he's got a great deal of discretion over what happens to those trust assets when he passes away. A significant benefit is the kinds of flexibility we have in trust drafting. It's also a private document. It's not going to be filed with the Register of Wills. Unless there's a dispute that's litigated, it's not going to be filed with the court. There are requirements in Maryland law and every state law regarding disclosure to the qualified beneficiaries. So it's generally not going to be a secret trust, but there is a great deal of flexibility and creativity that we can have with the trust. But you have to be very clear on what it is you want to achieve with the trust, because we need to write different kinds of trusts for different goals. For a revocable living trust, the way that it works in general is we establish the Joe Smith Living Trust. We have a much shorter will, so it's not, people will say it's a will substitute. It's just that the will itself is not directing as much activity, because the meat and the potatoes of what you want to have happen to your assets are all contained in the trust document. You're still going to have a will. We call it in legal terms a pour over will. The will is just much shorter. It just says, I give everything to my trust, or I want to distribute it according to the terms of my trust. And I think, again, the car is probably the easiest example. Sometimes after a person passes away, there's very commonly, there's going to be an income tax refund for that last year of filing. The IRS has to write it out to Joe Smith's name. Where's it going to go? Well, we have to open a probate estate to address it, because it's written to Joe Smith. It's not written to the Joe Smith Trust. The IRS won't do that. So we almost always end up with some small amount of assets that are going to require filing for a small probate estate. So we have a will. It's just that the administration of it is very streamlined, because there's very few assets going through the will. And we then are usually just transferring, consolidating all the assets into that person's trust. And whatever the trust directions are for post-death distribution, that is what we then look to determine what happens to the assets. The benefits, it's streamlined. You can especially imagine the benefit if a person has a dementia diagnosis. So let's again take the example of the house. They're living in the house, they're working on their goal of aging in place. Private care is being brought in to assist the person with that goal. As they're unable to manage their finances, they've retitled their investment account to the Joe Smith Revocable Trust or Living Trust. Their successor trustee then takes over managing investments because Joe has lost capacity. When Joe passes, there's a more seamless process where the trustee already understands Joe's financial estate and what he owns, and now they're operating under a different section of the trust, which is the post-death instructions, whatever happens to the house. Without a trust, these steps still happen. Someone's wearing a different hat. So while Joe is alive, they're wearing the hat of financial agent, and they're operating under his financial power of attorney. The day Joe passes, the financial power of attorney has no more validity. We go to the court. Now, in some courts, it just takes a couple weeks to get the order approved. Honestly, it takes that long to get the death certificate anyway, before everybody is sort of ready to start taking those first steps. And then the person is acting in Maryland, we call that person the personal representative, which other states call the executor. So it's at that time that then whoever has been appointed to manage Joe's estate, if it's as trustee, they're working as trustee. If there was no trust, they're working as appointed personal representative, or in other states as executor, to manage affairs. The work they're doing to sell the house or distribute the investment account is the same, but the pathway, the legal document they're operating under to get there is different. And so what a living trust can do is provide more continuity. I will be honest, as a drawback to the living trust, I want to be very transparent. It's more work for the asset owner up front. We have to retitle assets. We have to go through the trust, which can be a more extensive set of planning documents. It requires more attorney involvement up front, and the cost of retitling real estate. But then you know it's done, and that peace of mind has value for some people. While a person's alive, having a living trust generally, and I'm speaking very, very generally, the most common way people set things up. There's no tax savings while alive. There's no creditor protection while alive. The real benefit is in a smoother estate administration process, either when they lose capacity or upon passing. It also provides privacy. The trust it does technically in Maryland have to be filed with the Register of Wills so that they see it, but it is generally not in any way going to be a public document. It's not available for anybody else to review. It's just that the Register of Wills wants to see that the trust does exist if assets are getting transferred into it. So it can really simplify the administration, including and in particular if you own real estate outside the state of Maryland, because everything has been unified under the umbrella of a trust. And so if you own a beach house in Delaware, you don't have to go through the Delaware Circuit Court to get approval to sell the house. It's just the trustee working under this unified umbrella of your living trust or revocable trust, however it's titled. So there are pros and cons, and I think again it comes down to you balancing out your values, your priorities, and your asset portfolio. It's just a discussion with the estate planning attorney you've engaged to figure out what makes the most sense. And I would say, you know, this transactional versus educational approach is really the key to the difference between how you can go about estate planning. The transactional approach to estate planning is this sort of DIY, the view that the document itself is the estate planning. And Cortney and I are going to say that the document itself, having a will, is an important piece. It's necessary, but not sufficient. And a big part of what Cortney's going to discuss is the actual implementation, what she called the softer side. But if you have a document, there's a lot left to be desired in how your family's actually going to see it through. There's also no guarantee that it's properly updated as you have life events happen. And I'll just say the DIY trend, go online, free drafting, I will say without question, you get what you pay for with those free documents. In my experience, an educational approach to estate planning, which is what Cortney and I are trying to do here, our goals are to help you identify what you want, have a holistic approach where we look at not only all your assets you have now, but inheritance you may have in the future, retirement, what your plans look like then. It's really building your team. It's your accountant, your financial planner, your lawyer. If you do have dependents, it may be guardians or your care manager. It's building that professional team and making sure that the team is synced up to achieve your goals. And I think that's a really good transition now to Cortney and the family love letters, which is once you have the documents, you've articulated your goals, what happens next? So with that, I'm going to say to Jeff, just if there's any questions that are just quick clarification questions, I can take them now. For anything more substantive, I think we'll hold them till the end. So I'll turn it over to Jeff and Cortney now at this point.
Thanks so much, Lily. Really appreciate great information. So we'll see if there's any brief questions here. And in the meantime, Cortney, I'm going to go ahead and make you the presenter so you can share your screen and slides. And looks like Lily, maybe a brief question here. When does a trust go from revocable to irrevocable?
So the usual way that we draft these is that a living trust becomes irrevocable upon the death of the grantor, who's the person establishing it. So in my Joe Smith example, he retains authority to amend or completely rewrite or revoke, terminate the trust through his lifetime. One discussion point we have is if he's alive but loses capacity, to what extent can what happens, what are the rights of his successor trustee, let's say his adult child or his attorney, if that attorney's the trustee, to make changes. But then upon his passing, it's almost absolute. That is when it becomes irrevocable. No further financial activity can occur under his social security number. And we get the trust its own tax ID number. The reason it becomes irrevocable at that point is because the person who distributed the assets into the trust, so Joe, we now are protecting his estate plan. So nobody can change the terms of his estate plan. It can work a little bit differently with a married couple. It depends a lot on their view of the assets, the degree to which the assets are joint and blended, the degree to which they would like to hold money out separately to preserve for children in the future. So it's a very specific conversation to the family. But in general, the answer is it becomes irrevocable upon the death of the grantor, the person who established the trust.
Okay, Lily, thank you. We do have a couple more and we'll hold this till the end. And Cortney, it's all you.
Great. Can you guys see my screen? Because I can see my screen, but I can't see you anymore. So I just want to make sure everyone can see.
Absolutely, yes. Looks good.
Perfect. Okay, so we're going to discuss the family love letter. And like I said, it's the softer side to your whole estate planning, right? It's an actual program. It is a workbook that you go through in preparing this. Like I said, it's it's a love letter you're writing to your family, right? It is, the whole goal is to take some of that burden, that stress, that confusion away. So you've gone through the hard work of getting your documents for life, because I know that can be a heavy lift. It's a lot of work. It's talking and thinking about things we maybe don't want to talk about, right? Talking about, our death or our incapacity is never fun. But if we plan well and we execute well, it can make it a lot easier for our loved ones once we're gone. And I'm really talking about the execution of that, of those documents, the nitty-gritty behind it. The family love letter, it's not financial, it's not a legal document. A lot of times, Lilly will recommend to you all that you write a letter of intent that goes along with, say, a special needs trust that talks about your child and what they need, or a letter of intent that goes along with your trust for how you want your kids cared for if you're gone too soon. This is like that on steroids. It's a system that helps you get your house in order, right? Think of it this way. I tried to eliminate the junk drawer in my house. I did this in November, and it's kind of working, but kind of not, right? We're kind of getting little other junk cabinets around, but we all usually have a junk drawer, right? We have that place that we just put the stuff that we don't know where it goes, right? So think of what happens when you're gone and your kids, maybe you're incapacitated, maybe you've passed away, and your kids, or even maybe your wife or your husband, is now set to figure out what these keys in your desk drawer go to, or what this paper crumb trail of breadcrumb trail of papers that you have going through your house and your office mean and lead to, right? It can be confusing, and mistakes happen in that way, right? We all have a paper trail, digital or actual paper. It's there, and it can be pretty daunting to figure out. So we want to leave our loved ones a map of, this is what I have, this is where it's at, this is who to contact, Here are the statements, all of that that goes along with every aspect of our lives, right? The opening page of this family love letter is really a letter. It gives you an opportunity to, write something down for that person who kind of picks up the ball, and has to carry on. So, what do you want to tell them, and what will help make this process easier? But the real guts of it is the data. And like I said in the beginning, I'm a financial advisor, but I've lived through a number of these situations myself and with clients. So let me share with you a story of a father, military family. Father is deployed. Wife and daughter are home, and she has special needs. The wife is the one who's always been there, right? She has been to every doctor's appointment. She knows every medication that their daughter has ever taken, every surgery. She has complex medical needs, every caregiver that she sees, every specialist, all of that. She knows about her Medicaid waivers and attendant care and all of everything. Mom knows. It's all right here. Mom was in a car accident. Dad comes home from being deployed, is taking over, and has no idea where to start. For me, that really opened up my eyes, right? Because I think in whether you're a special needs family or any family, we very much divide and conquer, right? This is my area, I take care of this. This is your area, you take care of that, right? I take care of the finances in my house. I also take care of our special need child. If something happened to me, my husband would not have a clue. That is what really got me started on looking into this family love letter and why it's so important, because it helps share that information to make it easier. It also helps in the cases of it starts the communication, because I don't want you to just, leave here today, reach out to Lilly and I, schedule a consultation, get your free family love letter, fill it out, and stick it in a drawer. Because that's not going to help anyone if they don't know where it's at or that there's even something they should be looking for. So it starts this conversation, right? Mine literally is in a folder that says to Justin and the kids when I die. Everybody in my house knows if something happens to mom, everything we need is in this folder, right? The Donna, who is the author and creator of the family love letter, she lives in California, and she was recently impacted by the fires. And we were hopping on a Zoom call, and she said, well, I have my love letter and I have all the supporting documents right here in a file folder. If we have to evacuate, it's coming with us, right? It starts that communication to your family. You need to make sure you're letting your loved ones know this exists and how important it is as well. So what is it? What is in this family love letter? So it's broken up into a variety of sections. The first one is your advisors and your financial information. It talks about who is your CPA, who is your financial advisor, who is your attorney, what assets do you have and how are they titled? Are they in a trust? Are they in your name? Do you have military or survivor benefits? What retirement accounts do you have and where are they? I don't advise people to put account numbers and balances in here because that's going to be outdated the day you write it, right? But tell your family in here, all my retirements accounts are with this financial institution. I have four accounts, or I have 3 accounts, or whatever, and the purpose of them. Cash and cash equivalents, that's going to be your bank accounts, credit unions. Where do you have money so that they know where to go? And what I say is, instead of doing those account balances and account numbers in here, create a folder and stick your year-end statement in it or your last quarter statement. And you don't have to update those statements every quarter, maybe once a year, maybe every couple of years, maybe whenever there's a change, if you change account numbers, things like that, update the statement. But at least it gives them a starting point of where to go. Another thing that we forget about is our frequent flyer miles and reward programs. A lot of times those are transferable. So if you're someone who has a lot of you know, airline miles or hotel points, you don't want those to just disappear. Notes receivable, this might be any loans that you have given to people. Maybe you have, loaned your child some money. Do you want that to come out of their inheritance? Is it forgiven upon your death? What do we do with these notes? Are you party to any lawsuits? Loaned and stored assets. If you have a storage unit somewhere that you have family heirlooms in or old furniture, or that you have artwork that has been loaned to someone, all of that would be included in here, as well as any medical assets such as stem cells or embryos, things like that. Section 2 talks about your liabilities. This is what you owe, right? This is usually fairly easy, our mortgage, our car loans, things like that. But the monthly budget, a lot of times people say, well, why do I need to put my budget in here? My kids don't need to know that. The key here is is really in the case of incapacity, not necessarily a death. But if something happens to you and someone, your husband, your wife, your child, your best friend needs to take over managing your financial household, they need to know who they need to pay each month, what are reoccurring transactions and when they happen, what are maybe annual transactions and when they happen. One situation I had, a family moved dad into a nursing home and stopped the mail, had it forwarded for however long that normal forward lasts. Well, apparently dad had a life insurance policy that was paid once a year, and that the kids didn't know about the policy. It wasn't in the checking account that they were looking at in the past few months, so they didn't see a payment or anything going out, and the policy lapsed. They only found out about it when they were going through documents to shred things, that they realized that policy had lapsed, which is very sad because you pay into this and that would have been a nice contribution to their inheritance. So we always want to make sure we have listed those things that we pay monthly, we pay annually, we pay quarterly, so that nothing falls through the cracks. The next step is our insurance and our benefits. Especially in the case of incapacity. If you have disability or long-term care, it's very helpful for people to know where to go to get that information, right? Know where those policies are and the details of those policies. Health insurance is usually a little easier. We usually keep copies of it in our wallet, but it's always good to keep in there. If you are over 65 and you receive Medicare, you want to list that down. Also, a list of your doctors and your prescriptions is a nice thing to put in here so that your family knows if, you are unconscious and you're taken to the ER and they say, what medications do they take? Having a list is very critical. Any other insurance you have, home, auto, umbrella, listed all here, as well as any government benefits or employment benefits that you may have. The section 4 is kind of a fun one for me. But it's the documents and other information, but it really kind of makes you start thinking about some of those items. So this section starts off with those documents for life that we were just talking about with Lilly, right? But also your personal and family documents, marriage certificates, copies of passports, copy of a driver's license, anything like that. If you have baptismal certificates or, anything that's important to keep in there for identification purposes, your voter's cards, all of that. Property titles and deeds. Have you paid off your car? Put the title of the deed in there. Have you paid off your home? We need that in there. All of that information should be in there, as well as any ownership in businesses. Do you have an ownership in a business? If so, hopefully you have a buy-sell agreement. We want to have all of those types of legal documents in there. Guardianship, trustee information, if you have a guardianship of a kid, or you have minors, what will happen to your minor children. Also, safe deposit boxes. That's a little, a little more old school, I'd say, but people still use safe deposit boxes. Where is the key and who has access to it? Those are very important things to know, because if we don't have proper access to a safe deposit box, it is a very tedious process to get that access through the banks. Digital assets is not old school, right? This is where we're going. What digital assets do you have? Do you keep all of your pictures on Shutterfly or Dropbox? What is your social media presence? What do you want to happen to your social media accounts when you pass? Where are your user IDs and passwords? If you have somebody who's going to be taking over as a power of attorney for you, they may need some of that. One situation that we had was all two-factor authentication went to mom's phone. Well, no one knew the password to mom's phone, right? So having things like that so that it makes it easier, right? Emergency contacts, social security license, driver's license, passport numbers, all of that I put under that personal and family. I know it's listed here kind of twice, I think. In this binder, literally special needs is like a quarter of a page, a third of a page. The special needs family member, I personally have a complete separate organizational process for that. And I'm glad to share that with all of my clients. But it's a 3-ring binder that breaks down everything that you need to know for your special needs, child or adult child, everything from medical to social security, attendant care, housing. There's sections on that for everything. So the special needs trust inside the family love letter is really just a go look here for this information. Pets, what's going to happen to your pet when you're gone? There is a pet trust. I'm sure Lilly can talk to you more about that if necessary as well, where you can add funds for the upkeep of your pet. Personal property disposition. This is what's going to happen to all of those little items, right? That are not listed in your will, like grandma's locket or the family Bible or the desk that great grandpa built, all of those items that may either have sentimental value to you or someone else in your family, or it could be an item that potentially causes conflict. We want to outline that in advance. And powers of attorney and also event death planning. There's a section on there in the family love letter that lets people know what you want, if you've prepaid or pre-made funeral arrangements, and if not, who do you want to be part of your funeral and how do you want that to work? Who do you want notified? Things like that. The last section is really kind of just a family history and ethical will. And this, of course, is kind of more the heartfelt and philosophical part of the family love letter, but just as equally important. But like I said, all of this is 2 things. It's not going to replace your documents for life. This is not a legal thing. This supplements what you're doing with Lilly and the team at Elville, right? It it is there to help your family navigate all of that in light of the legal documents you have put in place. The second purpose to me is really starting that communication process. I'll give you all an example. Lilly talked earlier about advance directives and, who is going to make that decision for you and what you want. I grew up in a family. I lost my father when I was 19. We had a bit of tragedy, and we've gone through these situations. My father was very ill, so those conversations, I think, kind of organically. But my aunt, who had no kids, she had us 3 goddaughters. She was always very open with what she wanted and what she did not want. We knew very clearly what she wanted in those final hours, and that she did not want extraordinary measures or anything that would just prolong a difficult week or a difficult month. However, as well as we knew that, the implementation of it is much more difficult. So that final week, as Aunt Peg's, in the hospital and her body is shutting down. She was a nurse. She was very aware of what's going on. Doctor comes in and says, "Well, Peg, we could put you on dialysis." I think that would be the only thing we could do to buy you some more time. She said, "You know what? Let's wait and make that decision tomorrow." So tomorrow came, numbers are getting worse. Peg, we should really, let me know, do we want to consider dialysis? She said, "I'm going to make that decision tomorrow." Tomorrow came, and she was no longer conscious. So it came to the 3 of us to make that decision. And we know in our hearts that she does not want to go on dialysis. Had she wanted to go on dialysis, she would have said it 2 days ago when it was first offered. But it was too hard for her to say, "No, I don't want to go on dialysis." She just pushed the decision a couple more days, right? So when we made that decision, when the doctor turned to us and said, "Are we doing dialysis?" we unanimously said no. Everyone knew the answer. We knew that in our hearts. Did not make saying it any easier for Peg or for us, but we knew it. And that, I think, is one of the greatest gifts that doing this family love letter can give, is it creates those conversations. It's one thing to name someone as your healthcare proxy. It's another thing for them to know what you actually want and to have had those difficult conversations. The third gift of the love letter is organization. Right? It's a checklist of what you have and where it's at. It's very comprehensive. It's going to be in your documents for life, your trust is going, or your power of attorney is going to say, give you the financial authority to do X, Y, Z, right? It's very broad. So it has, any type of account that you may have could be considered in there. Whereas this is actually a list of what you have, right? So that the person that is the trustee knows where to find those things and what you have. The storage of the family love letter is very important. This is going to have a lot of information about you in it, right? So you want to keep it in a safe place, right? Inside a firebox, inside a safe, things like that. Because you want to be able to have access to it, which is why I don't recommend a safe deposit box for it, because if everything your family needs to know is in here and they can't get into the safe deposit box, it's not going to help them. But wherever you store it, my family knows binder on the side of my desk, like it's there. I mean, a thief that might be coming into your house is not necessarily looking for that, right? But you do want to be conscious of it. And that's part of the reason I say don't write down all your account numbers and balances in it, right? But keep everything in a organized, safe place and make sure that the people who will be in charge know where that is. Okay. When you go through this process, you may discover things. You may discover that you don't have everything you need. You may discover that the trust you set up years ago really doesn't fit anymore because the trustees, the successor trustees you named are gone, or you would not want them to be the person. So you might need to update things. You may realize that a document you thought you had, you didn't set up. So you want to make sure you have everything and it's correct. You also, going through this process, may realize you need to update beneficiaries. A lot of people struggle having these conversations, whether it's about death or illness or money. It's sometimes, depending upon family dynamics, difficult conversations to have. The family love letter is a means to kind of get this information to your loved ones and help facilitate that conversation. I highly recommend having a family meeting once you have completed this. You don't want surprises and misunderstandings. You don't want there to be conflict among your loved ones once you're gone. And it also helps introduce the next generation to your advisors, to your accountant, to your financial advisor, to your attorney. It is important for us to know them, and as well as know you, so that we can help with a smooth transition. I have seen, we all have the best intention, and I will be the first to admit it was my New Year's resolution to do my daughter's special needs binder this year. Because while I have been doing this binder program in hard copy as well as electronic for my client for, I think, 5 years now, mine was sitting empty. Procrastination is the number one reason of not getting that it's not getting done. It's not the best topic to talk about, but it is very important. So, don't try to sit and do it all at once. Break it up into sections. The first thing I tell clients when they get the family love letter is go through and put a line through any section that doesn't apply to you. If you don't have military benefits, let's cross that out, right? It helps make things less daunting. And then as you have your morning coffee, do one section at a time. I'm taking it with me to the beach this summer or the beach this spring break to work on, because I know that that's just time I can sit at a table under some palm trees, have a fruity drink in my hand and focus on doing that. Might not be what everybody wants to do on their vacation, but I oddly am looking forward to it. So, in closing, Lilly and I are going to offer a free complimentary family love letter program to anyone who schedules a consultation with either one of us. So if the family love letter sounds like something you would like to do, and a gift you would like to give your family, please reach out to Lilly or I. We would be glad to meet with you and get you a copy of the family love letter, because we believe it is very important. And I am literally at 10:59, so like getting my 30 minutes, I think I deserve a little treat today for getting that in the exact time. So Jeff, what questions do we have? Let's start tackling them.
Well, thanks, Cortney. It's kind of like we planned it that way,
Yeah.
Great job to both of you. Thank you so much. We do have some questions, and just real quick, when we were planning this and getting all the information together, Cortney mentioned something that has always stuck with me, and it's in our initial invitation. I also wrote it down. We're all going to leave a legacy, but will it be a legacy of confusion or of information? And that resonates with me, and I hope it resonates with you too. And hopefully it's going to be the latter, and you've just heard some really great information that's been shared with you to help you achieve a legacy of information. So let's look at some questions. Got some time here, plenty of time. Let's start at the beginning. So what does it mean when people say, quote, trusts are taxed at a much higher rate than individual taxes, unquote? When do trusts get taxed? Can't the trustee retitle the asset out of the trust?
Oh, great questions. Maybe what would be good is I will take a stab at explaining it, and then I would love to hear how Cortney explains the trust tax rate, because there's different ways to explain it, and it's not totally intuitive. So I'll just go for it the way that I know how to explain it. So first of all, I just want to say from the outset, there's usually two different taxes we're talking about: income taxes and capital gains taxes. So interest and dividends on invested assets are going to generate income that are going to show up on somebody's income tax form every year, whether it's an individual or a trust tax return. Capital gains is only realized if you liquidate an invested asset or sell the house, for example. So there's different tax avenues depending on what exactly is going on there. But in short, for income taxes, you and I as individuals are subject to the federal income tax brackets, and I don't have them memorized, I apologize, but if you earn up to a certain amount, the first amount you earn is taxed at the lowest rate, and then every incremental amount up to the next rate is taxed, and it goes up to like 37% or something. So if you're sort of a middle income American as defined in the DMV, which is more than the middle average income American, you might be like around the 32nd percentile for the income tax bracket. However, trusts, if there is income generating to assets that are titled to the trust, the easiest example is some kind of investment that's generating interest and dividends. Even a high yield savings account that has a couple $100,000 in it is going to generate maybe $10,000 to $15,000 of interest income that has to be reported. Trusts have what we call a compressed tax bracket. Less income more quickly gets taxed at the very highest federal tax rate. So while $11,000 in interest for me might be at if I have no other income, at the lowest tax bracket of whatever it is, 24% or something, that same $11,000, if it accrues to assets that are titled to the trust, may actually be generated at or close to the highest income tax bracket, so at a 37% tax bracket. So what that means for people is that part of good estate planning is working in conjunction with someone with Cortney's expertise or with an accountant, because we have to think about where we're going to assign the tax. For a living trust, it's just going to show up on your personal income tax. There's really no question. But after a person passes away, the trustee of the trust at that time works with an accountant to figure out, based on the distribution plans, if there's income accruing to the assets in the trust, is the trust going to file a trust tax return that is and the trust itself is going to be responsible for those income tax, which might be at up to a third of the income is going to be payable to the federal government and then also state taxes? Or if distributions are being made, the accountant can issue a K-1, essentially assigning that income to the beneficiary, and that income shows up, then has to be reported to the beneficiary's income tax return, and they will be assessed income tax at what is probably a lower tax rate. In addition, depending on the terms of the trust, it could be the trust itself pays the tax that the beneficiary owes. So it's very fact specific whether the beneficiary actually pays the taxes owed, but regardless, it has to do with tax planning. So I just want to get that first question about the tax brackets addressed sooner. That's what people mean. And then I'll just say it's different with capital gains because no tax is assessed until the asset is liquidated. And so again, it depends on whether it's going to be held by an individual and whether they hold it through their lifetime, and then the asset is sold, house or investment accounts, or in the trust. You run into the same question, and it gets into whether it'll be taxed at the 15 or the 20% tax rate for capital gains. Courtney, do you have anything you would add or change?
Sure.
To hear how you describe it?
No, I think you did a great job, Lily. The only thing I would, add in there is there's a difference on the personal side between your highest tax bracket and your effective tax rate. So a client who might be in the 37% tax bracket, meaning they're hitting the highest tax bracket, not all of their income is taxed at that highest tax bracket. So they may be effectively at a 22% tax bracket, right? Which can be, much lower than the trust tax rate. But I think that the important part to all of this is determining why you're putting something in a trust, determining what needs to happen, and managing the taxes around that, right? There are a lot of benefits for having the trust that can offset any small tax bill that might be accrued because of that. So in most cases, having that trust, especially while you're alive, is a pass through or see through to you. So it's still you, right? And once it goes to your descendants, like Lily was saying, if it's put through as a distribution, then it can still be taxed at your beneficiary's income tax rate and not necessarily the trust tax rate. So it all comes down to not just determining what's the best trust and structure for you with someone like Lily, but then working with a CPA that really understands this. So not just an enrolled agent at H&R Block, right? But working with getting good legal and accounting and financial advice so everything works together.
In particular, if the bulk of your financial assets are in a pre-tax retirement account and you're considering, for whatever reason, naming a trust as the beneficiary, and there's reasons people need or want to do that, but then you'd be very well advised to speak with an accountant to fully understand what is going to happen to the income tax when distributions from that pre-tax account are made. And Jeff, I think there was another point to the question. Is there anything to that question we didn't address?
Last part was, can't the trustee retitle the asset out of the trust? I think you alluded to that. When do trusts get taxed? I think that's covered for the most part.
Depending on the terms of the trust, and you have to think of the trust as an instruction manual. So it depends on the terms of the trust, but typically for a living trust, the person who established it can take things out of the trust. And there are times we do have to do that for any number of reasons. So it's simply retitling to undo the action that was done. And then the trust gets taxed. If you almost think of it as a business entity or even an individual, it is responsible for, if there is financial activity, the tax man's got to get paid. So for certain, there's the April 15th standard tax timeline. If this is taxes in respect to someone who's passed away, it's possible that the taxes are due on a different time frame. I have not had clients discuss with me the need to make quarterly estimated tax payments for income being paid to a trust, but I would assume that is required if you're generating quite a bit of income and there's no withholding. So in that sense, just think of it as a business or an entity. You pay tax certainly on the tax, the tax cycle that we all pay taxes on. And then it just depends on the specifics of the trust when taxes are due or can be withheld, just like we can have taxes withheld from certain transactions we do as individuals.
Lily, can I add one thing there that you were saying about the IRAs? So that's a really big point that Lily touched on. So if you have a traditional IRA, that means it's pre-tax money. The government has never received any taxes on that money. They eliminated a few years ago with the Secure Act, they eliminated the stretch IRA, where it used to be when you inherited it, you could stretch your required minimum distributions over your lifetime, which was much more tax efficient. Now they say you have 10 years and trusts have a shorter time period, with the exception of special needs trusts, to liquidate that. So if you are giving, let's just say $1 million to your child in an IRA that you never touched, they have to take $100,000 out each year, assuming there's no growth in it, so more than $100,000 each year, which is going to impact how much taxes they are paying, right? Because that's, if you, maybe they earn $200,000, now all of a sudden they're earning $300,000 in income. That's going to put them into a higher tax bracket. So we also want to look at how that money is left, and what's the best way to liquidate that type of asset. Maybe we even do Roth conversions while you're still alive so that we're getting money out of the required minimum distribution cycle. There are strategies that your financial advisor and tax accountant can work with you on in years where your income might be lower, to kind of offset with Roth conversions, a bunch of different things we can do there, okay? But if you leave money to a special needs trust, which we will be getting into in our next seminar, that is stretched over the course of the lifetime and is not held like the other trust to a shorter time frame. So there's a lot of intricacies there, which is really why having a team is so important.
Right. To go back to that one slide I had that showed a little jigsaw puzzle. Again, it's really about holistically what your plan is. Because like a concrete example, you have $1 million pre-tax IRA, you have 2 children. One of them is entered into a career where they're earning a great deal of money and reaching that highest tax bracket. The other is opted into a different life for whatever reason, whatever their circumstances, doesn't have a disability, but their income is very low. If you split that IRA 50-50, yes, there is equality in the sense that they're both entitled to withdrawals from an inherited IRA of $500,000. But you haven't really maximized your opportunity there to have a tax efficient outcome, because for the child that is earning much less, their withdrawals probably aren't going to reach those top tax brackets, and they may have more deductions depending on their situation than your other child. So even just splitting your IRA 50-50, while absolutely looks equal on paper, has disparate incomes, disparate outcomes. So that's something that my role is to identify for you and advise. Then you go talk to Cortney, you go talk to an accountant, and you figure out what you want to do, and we align it across all your different assets.
Yeah. The Secure Act really made it so assets are not equal, right? So
Yes.
Giving the house to one child and giving the IRA to another could be equal, even though they're not valued at the same. So it really takes some advanced planning. I'm sorry, Jeff, I heard you come in there. What's our next question?
Oh, that's okay. Great information. Thank you. Next question is, Lilly said investments can be retitled into the name of the trust. Can IRA investments be retitled into the name of the trust?
I'll go ahead and handle that one, Lily. No, IRAs by definition are individual retirement accounts. So retirement money cannot be titled into the trust unless they are liquidated and you take the tax hit and you take them out of the IRA or the Roth IRA, which in most cases we don't recommend unless it's a strategy of tax reduction in the future. But to just lump sum, I'm going to change it so I can put it in my trust, not a good idea. That would be a huge tax hit. However, you can leave your trust as a beneficiary. And with the Secure Act, I'm not sure, Lily, and it might be state specific, but if you leave the trust as the beneficiary and the trust says to disperse to these two beneficiaries, will it see through to them, or so it'll go by the 10 years to them, or will it stay at the trust number?
It's a great question because they changed the rules partway through the implementation period. I still thought it was 5 years, but that's something that I need to double check. So
Okay.
it's an
I've
open question in my mind.
Yeah, I've heard that depending upon how the trust is written, it can go by the beneficiary's lifetime. But I usually advise, because as you can see, rules change, right? Leave it to a person, not the trust, right? Unless there isn't a person to leave it to, right? Leave it to your spouse. Maybe the trust is the contingent and it sees through, or leave it to your kids. And a trust can be a contingent if they're, your kids predecease you and don't have descendants. So I like keeping IRAs to the benefit of actual people, and the trust is the backup, just in case those laws continue to change and morph.
All right, next question is, I have a revocable trust in Maryland, but have recently moved to Virginia and am a Virginia resident. Do I need to create a new trust in Virginia? If not, what are the drawbacks of a Maryland trust but passing as a Virginia resident?
This is a pretty common scenario. So first, I think moving to a new state is always a trigger that I recommend having an estate planning consult with an attorney licensed in that state. So it's really going to depend on the advice you get from counsel licensed there. The trust is still valid. The terms are still valid. So you look to the document itself for the rules of the road. It probably is going to work fine. It's going to be, I would defer to the attorney that you talk with. It doesn't mean that you need to junk the trust. And really what they would do is what's called a restatement, which means the titling all stays the same. If you think about it as a book and you have a book jacket cover, the book jacket cover stays the same. The question is whether we need to rewrite the pages inside of it. So you don't necessarily have to do a restatement, which is to change the terms of the trust to incorporate Virginia law. But I do think you should talk to an attorney licensed there. And people focus on the trust, but I actually think what most concretely comes up right away is the financial power of attorney. So making sure that you have a financial power of attorney that will work in that state, because states are taking more and more state-specific approaches to powers of attorney.
Okay. Our next question is, can you please explain further what an ethical will is?
I don't know. I've not heard of an ethical will.
So in the family love letter where they talk about the ethical will, and this was written by people out in California. So they do have different terms and verbiage, but it's not anything that, like I said, is legally binding. But on the ethical will, I'll read you some of the questions that it has for you to write. When I'm gone, I hope my family will learn from my experiences. Like, I believe the most important things in life are. The most important thing I've done in my life is. It is my hope that my family will use its inheritance from me to accomplish the following goals, dreams in their lives. The most important values and traditions I would like to pass on to my family are, and this is how I would like to be remembered. So it's much more of a kind of a personal philosophy, and I think that really the important line there is, this is how I would like them to use their inheritance. right? It's really just your hopes and dreams, your reflections upon your life. It's not a legal document. It's not something you have to have Lilly write up for you. So um, it is one of the pages in the family love letter, which I think that's where the question came from.
Okay. And last question for now. So now's a great time to get any final questions in for Cortney and Lilly. Any CPA recommendations that have experience with special needs trusts? You want to share that now, or maybe follow up with our attendee later?
I'm hoping to meet one next week. Lilly and I are both attending the Academy of Special Needs Planners. It does not seem to be a specialty like it is in legal and financial circles. And I've had to do quite a bit of educating along the way for accountants. But I don't have a specific one that I can recommend at this time that is very well versed. Lilly, I believe you're kind of in the same boat, right?
Yes, and I've really searched, but I'm happy to share the feedback I get. So I think we all know there's a mass exodus and retirement of CPAs, and of the next generation of CPAs, they're not doing as much of the personal income tax forms. They're moving into different areas of tax. So for accountants, the feedback I get is doing the personal income taxes it's a difficult business model. So they're looking for more steady flows of work stream. And so specializing in doing special needs trusts that are very intricate and have there's considerations that they want to make sure they understand. It's just from a business model standpoint, very difficult for accountants to want to take that on. I met one financial planner at an event who had a real interest in and love for working in the special needs community. She offered as a service to the clients whose funds she manages that her team will do the taxes for the special needs trust. But it's not a standalone service because she doesn't want to be turned into a tax preparation firm. They run an investment advisory firm. So she viewed it as an add-on to their existing clients, a value add, I guess. So you're not alone in the search there. I can say that right now my conclusion has been to find an accountant who is responsive, who doesn't mind looking things up, who is willing to engage with you and be prepared. The trust can pay the cost of their services. It is a specialty niche service, so you should be prepared that the invoice is going to reflect that expertise for them.
Okay. All right, those are our questions for now. I'll keep an eye out for any last ones. We're going to wrap up. Lilly and Cortney, thank you so much for a great first part of our series. And so I do several things after our webinar series presentations. For those that are new, I'll be sending out the slides again, as well as the video recording, which a lot of people like to review and send to family members. Also, I'll send out contact information again for Lilly and Cortney. And our webinar series is very busy, very busy. It's March Madness, college basketball starting today. It's March Madness for the webinar series. So it's been very busy. Tomorrow, Lilly and I are going to be at Rockville Senior Center for estate planning and elder law essentials. Always one of our favorite places to be. So hope you'll consider visiting us at 10 o'clock down at Rockville Senior Center. Beautiful place. Then on March 27th, I've got a real treat for you. Housing options as you age with our good friend Victoria Hathaway, who is the director of Silver Group of the Keller Williams Lucido Agency, and Emily Leclerc, who is a program manager with the Office on Aging and Independence for Howard County. So that's really looking forward to that one. A couple other real quick highlights. Our wellness series comes back on April 8th. Maintaining your reserves in changing times. We have Dr. Michelle Fritsch, who's a great friend to our wellness series and our firm here. And then on April 25th, you're all going to get an invitation to the second part of Lilly's and Cortney's series, Special Needs Planning, Financial and Estate Planning in Unique Circumstances. So you'll have an invitation out by the end of the week for that. So look for that in your inbox. Any final thoughts, Lilly and Cortney?
Thank you all, and we look forward. We hope you can join us for the second part of our presentation.
Thank you very much. Have a great day, everyone.
Great. We'll see you again soon on the Elville webinar series. Have a good rest of the week and a great weekend.
Take care. Bye-bye.
Bye-bye.